What is the supreme law of the universe? The Bible, God's law. What is the supreme law of the land? Constitution. And the amendments made there too. Now, we know the first 10 amendments, called the Bill of Rights, they're really an essential part of the contract. Because the people who ratified the Constitution, the Anti-Federalists and the Federalists were fighting and discussing, and the Federalists said, it's fine just the way it is. The Anti-Federalists said, no. Without a Bill of Rights, we will not accept this Constitution. The Federalists promised, yes, you will get a Bill of Rights. The very first thing Congress will do will be a Bill of Rights, and by God, they actually fulfilled their promise. The first thing they did was a Bill of Rights. So the Bill of Rights, the 10 amendments, they are essential to the Constitution. They cannot be removed. They cannot be changed. They're part of the original contract. However, the subsequent 17 amendments, 11 through 27, are additions that can be altered, can be amended, and actually can even be removed, as we'll see here today of one example of one amendment that was completely removed. And so this morning I want to look at the 16th and 17th Amendment, but before I do, I've got to give a couple of warnings. How many of you receive a paycheck as a W-4 employee? That is, you filled out one of those W-4 forms, and so you know what it is when you receive your paycheck. You see all these deductions. I know some of you have worked a job where you get a W-4, and you see all those deductions out of your paycheck. We're going to talk about those deductions in a moment. Those of you who haven't had that experience yet, you may well have that in your lifetime. And so what I'm going to talk to you about this morning is a rather painful experience to go through, because you're going to examine what actually took place with the ratification, quote unquote, of the 16th Amendment and the ratification, quote unquote, of the 17th Amendment, and it might make you angry. I know it made me angry when I first discovered this. So wait a minute, I've been lied to and deceived. Okay, so let me give you that warning. This might upset you. It might make you angry. You might leave here more trouble than you are right now after hearing about all the election fraud that our good friend Kurt presented to us in the last two sessions. That's the first caveat. The second is, I am not giving you any legal advice. I am not a lawyer. I am not practicing law. I'm not pretending to practice law whatsoever. Secondly, I am not giving you any advice about any government document that you should fill out, should not fill out this way, that way, the other. No. I am not giving you any advice regarding what you do in your relationship with the IRS. None of that. So please don't allow me to be accused of being one of those who is advocating against the system and therefore should be incarcerated, as I've had some friends who are incarcerated when they are known as tax protesters. I am not doing that. What I am doing is sharing with you the history, and the history that can be proven, not some speculation. This is the history, and I'm also sharing with you what the Constitution actually says. You know, this word is all too common from our federal government. I love spending money because it doesn't cost me a dime. It costs you and I, the citizens of these United States, a great deal. Where are we? 36 trillion? I've lost count. We're so deep in debt that our generation of children and grandchildren, we're never going to see that debt paid off. It may take 100 generations before it's paid off. So we are in a mess because Uncle Sam has gotten drunk on his ability to spend other people's money, specifically your money and my money. So think of it, if you're ever experienced being a W-4 employee, you signed a form that said your employer can take money out of your paycheck before you even see that money. You've earned the money. Supposedly it's the fruit of your labor. Instead of the fruit of your labor coming to you and you making some decisions about how to use that fruit of your labor, the fruit of your labor immediately is taken out before you even see it. This is, my view, one of the most wicked things done in this system of taxation is to steal it from the people before they even get to enjoy it themselves. And then it's taken from you and it's sent to the Department of the Treasury. And the Treasury Department gathers all those funds together, billions of dollars from all the taxpayers in America, and then they deliver it to Congress. And Congress passes all sorts of legislation about this, that, and the other thing. And by the way, a lot of it stops there, of this money that's going. A lot of it doesn't continue to the next phase. They keep a lot of it in Washington, D.C., and then through pork barrel and other ways, primarily through grants, they send the money on not to you, but to your state government. And the problem with this system is the state government then becomes dependent on federal grants, money coming from the federal government, and therefore, who is the state going to answer to when it comes to push and shove? And you, the citizen that supposedly elected them to represent you, or the people who are supplying the funding of money from Washington, D.C., and it's often the people funding the money they're going to listen to, they're going to obey, and they're going to follow and disregard you as the citizen who's actually paying this bill. But because it's taken out of your pocket first, before you even see it in your pocket, sent to the federal treasury and then to the Congress, you are not in a position of any power in this situation. Now, I'm going to ask you to think clearly. Was that the design of our founders regarding federal taxation? That the federal government can reach into your pocket, not even your pocket, your paycheck, before you even see your paycheck, take the money out of that, and then send it to Congress, where they're going to decide how to spend it, part of which they're going to send back to the states as what I would call a bribe to get the states to do what the federal government wants the states to do. And I would argue that's not the balance of power. That's not how our founders set it up. If you want to see one founder who clearly expressed that, James Madison in Federalist Paper 45. We don't have time to look at that. But consider what the Word of God says in 1 Timothy chapter 1, verse 8. But we know that the law is good if a man use it lawfully. And of course, it's referring there to the Word of God as the law. But the same principle applies to our Constitution. Someone might take and twist the meaning of these words. Someone might take and use this law, supreme law of the land, and use it in an evil way, use it unlawfully. And that's what I would argue was done with these amendments. And so you see there the full cycle. Comes out of your paycheck, goes directly to the Department of Treasury before you ever see it, before you ever have the opportunity to spend it at all. Congress then makes all decisions about how that money is going to be spent, some of which, just a small portion of which, not nearly 80% or even 50%, some small portion comes back to your state government to bribe them to be the lapdog of Washington, D.C. and do what Washington, D.C. says, or else their money supply is going to be cut off. And that's the last thing that their state government wants to see happen. So let's look at the 16th Amendment. 1913, by the way, a very, very bad year in the history of our constitutional republic. Federal Reserve Act was passed in that year, 16th Amendment. So a number of other very bad things happened in 1913. And Congress, the history behind what took place in 1913, Congress passed an income tax in 1893, quite a few years before. But the Supreme Court ruled that income tax passed by Congress unconstitutional. They said it violated Article 1, Section 9. And so Congress, responding to what the Supreme Court had done, I believe the Supreme Court did the exact right thing here, Congress responds, okay, then we're going to pass an amendment to the Constitution to get around what the Supreme Court said about this income tax being unconstitutional. And supposedly it was ratified in 1913. We'll look at that in a moment. You see, there was problems with that ratification. There was one individual, his name is Bill Benson. He decided to do a little bit of research following the supposed ratification. And as you know, if an amendment to the Constitution is ratified, it has to be ratified in all the states that exist in the Union. In 1913, it was only 48 states. Alaska and Hawaii had not yet entered the Union. So he did a research project by going to the archives of every one of those 48 states and examining the section of the archives that dealt with the ratification, supposed ratification of the 16th Amendment by that state government. And he analyzed what they had said, the debates that took place, the votes that were made, and what the outcome was in all 48 states. And he published a book called The Law That Never Was as a result of his research. And he found 10 problems with those supposed ratifications in the 48 states. In some cases, 7 cases, it was not ratified by the state government, and it was so reported to Washington, D.C. that it was not ratified. That was just 7 states. Another 2 states not ratified by the state legislature, but reported as ratified. Somebody lied, either at the level of the state reporting they ratified it, or the level of the federal government saying, oh yes, that state ratified it. Somebody somewhere lied in 2 of those states. Thirdly, the governor failed, or another official, which was required by that specific state constitution, and this is 6 states. By the way, that's more than 13 necessary to kill this amendment. But the governor or official of the state did not do the duty they were required to do according to the Constitution of that state government. there are other problems as well when we look at this. And he found other violations of state constitutions and ratification. That's 25 states where there were violations of this. And so he concluded, in some cases, they approved the amendment, so-called, but they changed the wording. Now imagine this. Let's imagine you guys are Congress, okay? Just for a moment. You're Congress, and you're the state legislature. Congress sends the 16th Amendment to the state, say, you guys ratify this. And you look at this and say, you know, I don't like the wording of this amendment. Let's change the wording. I don't like the punctuation. We're going to change a number of things, and we're going to send it back to Congress. Has that state ratified the amendment you sent to them? No, not at all. They changed it. They said, yeah, this is an okay idea, but you got to change all these things. You cannot leave it. We're not ratifying what you sent to us. We're telling you, here it is. Here's what you need to change. And that was 22 states did that. And you look at it, of the 48 states, 36 were required, an absolute minimum of 36 states which would ratify the 16th Amendment for it to be legitimate. So you do the math. If only 13 states rejected this amendment, it would not be legally ratified. Okay? So keep that number 13 in mind here, and let's look at exactly what happened. Knox, who was Philanderer Knox, I can't imagine parents giving their kids that name. First name Philanderer? My goodness. If you know what that word means, okay? It means somebody unfaithful. Anyway, Philanderer Knox was the Secretary of State at that time, and he received only responses from 42 states. How many states were in the Union at the time? 48. Okay, so there were 6 states that he had not received a response yet, but he was eager to count the vote before the vote was finished, because the other 6 states hadn't responded. What in the world was he doing counting votes when the 6 states had not yet responded? He was cheating already. So Philander, winds up being an appropriate first name for this guy. He rushed to declare the 16th Amendment ratified February 25th, 1913, just a few days before he was leaving office to make way for the administration of Woodrow Wilson about to enter the White House. Knox acknowledged in his statement that 4 of the states had rejected this amendment: Utah, Connecticut, Rhode Island, and New Hampshire. Good job, New Hampshire. And then that means we now have 10 states. He didn't hear from 4 states. He has an additional 6 states. He didn't hear from 6 states. He has additional 4 states that rejected it. There's the number 10 out of the 13 that are needed. And so he only needed 3 more states to reject this amendment to the Constitution in order for it to not be ratified. So let's look at 3 of those states. There's many more, but let's look at 3. Kentucky. The legislature acted on the amendment without having received it from the governor, which is what their state constitution required. It was supposed to be transmitted from the governor to the legislature. That was not done. And so the version of the amendment that the legislature of Kentucky was looking at was not actually the amendment itself. In fact, it did not have these words "on income" in the text of the amendment that they looked at and they ratified, supposedly ratified. And when they realized, wait a minute, we made a mistake, they backtracked, and with the help of the governor, they looked at the actual text of the amendment proposed by Congress, and Kentucky Senate rejected it. They said, no, this is no good. We're not going with this. And yet, Philander and Knox counted Kentucky as approving this amendment to the Constitution, even though the Senate of the state rejected it. Another state, Oklahoma. Legislature changed the wording of the amendment so the meaning was virtually the opposite of what was intended by Congress. So you guys sent something to Oklahoma, and Oklahoma said, we're going to turn it all around and send it back to you. And then Philander and Knox says, they approved the amendment. Absolute lies. Knox counted Oklahoma as approving it despite the memo from his chief legal counsel, Reuben Clark, that states they were not allowed to change it in any way. That if the state legislature changed it in any way, it was not being ratified. But Philander Knox, the unfaithful fool, went ahead. So now we're down, not 38, we're down to 37, which means we're right at the border here. And attorneys who have studied the subject have agreed that Kentucky and Oklahoma should not have been counted as approved by Philander and Knox. Moreover, if any state could be shown to have violated its own state constitution or the laws of its own approval process, then that state's approval also would have to be thrown out. And that's where we get from 36 to 35. Tennessee, a state that prohibited its state legislature from acting on any proposed constitutional amendment to the United States sent by Congress until after the next election of state legislators. Their intent of course, was to give the proposed amendment a chance to become an issue in the state legislative elections so that the people would have a vote through and a voice through determining their legislators who were either for or against that amendment. It also provided a cooling off period to reduce the tendency to approve of an idea just because it happens to be the latest trending idea. Tennessee legislature did not hold off on voting. They violated their own law for this amendment. They didn't wait until after the next election. They acted upon it illegally. They acted upon it immediately before they were authorized by their Constitution to do so. And so they violated their own Constitution, failing to read the resolution also on 3 different days as their Constitution commanded them to do, Article 2, Section 18 of Tennessee's Constitution. And so these state constitutional violations make the approval of the amendment null and void. Their approval was and is invalid, bringing us the number of approved states down to 35. In other words, 1 state less than required for ratification. Now we could look at the rest of the research done by Bill Benson and show there's a lot more than just those 13. There's probably close to 20-some that also violated either their state laws and their state constitution regarding it or violated by rewriting the amendment and sending it back to Congress. So Bill Benson did a wonderful work for the citizens of these United States by researching in every one of those state archives what was done, making a record of it, putting it into a 2-volume book. And can you guess the reward he was given by the federal government for doing exactly that service to we the people? Can you guess? He's behind bars. That's right, he was put in prison. His book was banned. He was forbidden from selling his book, and it's very rare. I know some people have found copies on the internet for about $1,000 of these 2 volumes because they're extremely rare. A friend of mine had one, and so I borrowed it and copied out the section of Maryland and saw what Maryland did. They changed some of the details of it and sent it back to Congress, and Congress said, oh yeah, Maryland approved it. Maryland legislature, no, they did not approve of it at all. So we have been lied to about the ratification of the 16th Amendment. And Philander or Knox, and this is quoting from the book, The Law That Never Was, Philander or Knox said this. Or no, this is what's said in the record about what Philander or Knox said. The only record of the 16th Amendment having been confirmed was a proclamation made by the Secretary of State, Philander or Knox, on February 25th, 1913, wherein he simply declared it to be in effect. But he never stated that it was lawfully ratified. I'm astonished when I came across this. This is unbelievable that we've been lied to so thoroughly about the 16th Amendment. And the lie, of course, is well covered up, and that's why they, told him he was going to jail. That's why they tried to destroy his book and ban anybody from buying his book. This is outrageous. But this is what happens in America when you have people who will not follow the supreme law of the land. When you have evil people in office, they are going to do evil things. So let's look at what the Constitution would require of any such taxing scheme that the federal government would develop. Article 1, Section 9. It contains a list of actions that are forbidden to Congress. In other words, Article 1, Section 8 gives a list of these are the powers that we're granting to Congress. Article 1, Section 9 says these are the things Congress cannot do. We prohibit them from doing that. In Clause 4 of Article 1, Section 9, it says this: no capitation or other direct tax shall be laid unless in proportion to the census or enumeration hereinbefore directed to be taken. Our Constitution requires every 10 years a census to be taken, and that census is going to determine the representation in the House of Representatives for that state. So when the census happens, there's a big brouhaha because, California lost a few seats in the House of Representatives because their population was less than, other states that were gaining population. So not only for representatives is that census to be taken, but notice it also says for purposes of taxation, that proportion of representation is also there. So a state like California that has X number of representatives, they're going to, according to this, have a larger tax burden than a small state like Vermont that only has, 2 senators and 2 representatives. So it's proportionate according to the state in which you reside. Which means if you're going to ever receive a tax bill, and we're going to show you in a moment that you cannot legitimately receive a tax bill directly from the federal government, but if you were to receive it, they would have to say, we can't send it to you. We need to send it to your state legislature, and your state legislature takes that money from you, combines it together with other people from your state, and the state legislature then transmits that money to Washington, D.C. In other words, Big Brother, Washington, D.C. cannot reach out and directly tax you. That's the structure our founders wisely built into this. Now, you might wonder, capitation, maybe not a term you use in your daily vocabulary. We all know what decapitation is, okay? So capitation is a tax imposed on the head or on the person individually. This is forbidden in Article 1, Section 9. So it means that no federal tax on the people, on the citizens, or on their earnings is allowed according to Article 1, Section 9. And this provision clearly forbids any federal direct tax unless it's levied upon and apportioned among the state governments in proportion to the population of each state, as Article 1, Section 2, Clause 3 requires. So each state would have a differing tax bill. My state of Maryland has about 6 million people. Let me just pick another state at random, say Indiana. I'm sure, is it 12 million or something like that? So if it was 12 million and Maryland is 6 million, Maryland would receive a tax bill from the federal government half the size of that which was sent to Indiana. It's a very simple and a very fair system that was developed by our founders. Each state is going to have its own tax bill from the federal government. So the representatives and direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers. That's the language of Article 1 of our Constitution. Now, we need to remember that the taxing power of the federal government, the government primarily functioned during most of its history without any income tax whatsoever. They functioned with tariffs. The only time that income tax was ever required was during times of war, when the federal budget ballooned because they had all these expenses. But in times of peace, tariffs alone were the way in which the federal government subsisted, and they did quite well. They didn't need anything more than tariffs. In fact, when this 16th Amendment was being proposed, there was actually a surplus in the federal coffers, a surplus that I believe should have been returned to the states. But anyway, it wasn't a matter that they needed more money, and we'll see what their real purpose was. It wasn't a matter of further funding the federal government. And so the federal government apportioned the tax bill to each state according to the proportions determined by the census. And each state would have to raise those revenues by means that the legislature of that state determined, and then forward the proceeds to Washington, D.C. And this meant there was no federal collection agency like the IRS. Each of your states would have its own taxing system. And if you didn't like the taxing system of your state, you had a great deal of power over that. You could appeal to the legislature, say, these laws are unfair. Let me ask you, as a citizen of the United States, can you appeal to Congress and get anything changed in the federal tax code? No. You have no power. We have no power. Congress doesn't even, none of the lines of the federal tax code are even written by Congress. It's all handed off to the IRS to develop that entire tax code, which is, again, against the design of our founders that wanted to protect us from a rapacious kind of federal government that would steal our wealth. So what we have in the system of our founders was that there was a check on the part of the states against the federal government. We're going to see in a moment how this links with the 17th Amendment, because basically anything that the federal government wanted to spend money on, the states were going to have to come up with the money for that. So perhaps some of you have heard about the bridge to nowhere in Alaska, $1.5 billion or something, that went to a little village with a half dozen people or something ridiculous like that. A bridge to nowhere. Well, that got passed because the states had no control. The rest of Alaska loved that bill, but the rest of the states said, wait a minute, we're not going to spend $1 billion on a bridge to nowhere. Why waste our money? We're going to have to go to our own citizens and get that money out of their blood, sweat, and tears to pay for this bridge to nowhere. We're not doing that. And so this check on federal spending was the wise design of our founders. You see, the senators appointed by the state legislatures, they were subject to recall whenever they acted contrary to the wishes of the state legislatures. And so the states could stop any and every federal spending they were unwilling to raise from the sweat and tears of their citizens by taxing them to pay this federal tax bill. So the states, if they approved of the federal bill, like the big beautiful bill, if they approved of that, they would be saying to their citizens, look, we're going to get more money out of you than we got out of you before because we just approved of this. And the citizens would either fire their state legislators or decide they're going to move to a state that would be more friendly to them as taxpayers. So the real issue behind all of this, what it really started off as, was a good design to bust the trusts. Monopolies were illegal in our country, and so what crafty businessmen did, like Standard Oil and so on, they would combine their businesses in a trust and thereby hide their books from the federal government. So the federal government wouldn't be able to determine that these people had a monopoly going under the guise of a trust. And so they had the Sherman Antitrust Act, and so they had the power to do it, but the trusts were hiding the books of the corporations from the federal government. So this was actually the purpose of the original idea of the 16th Amendment. It was, we need to get the teeth into the Sherman Antitrust Act of 1890. And so Congress, in order to do that, enacted that income tax, imposing a tax on the income. Notice what it says, the income of corporations. This was the 1894 law that they passed. In the case of Pollock v. Farmers Loan and Trust, the Supreme Court struck that down and said that is unconstitutional. They declared it unconstitutional because it was imposing a tax on income derived from property. And they said that is a violation of Article 1, Section 9. If you take an income on the source, the tax income on the source of income as property, that imposes a federal tax burden on the property itself. And they said that is unconstitutional, illegal, forbidden by the limitations on direct taxation in the Constitution, Article 1, Section 9. And they state that representatives, as we've seen before, direct taxes apportioned. So they knew they were following, the Supreme Court knew they were following the Constitution. They knew what Congress was attempting to do was unconstitutional. Along comes Howard Taft, President Taft, and he gave a joint message to Congress in 1906, June 16th, and in his presidential message he declares what the purpose of this proposed income tax was. You can look at it on page 3344 and 3345 of the congressional record. And he says this, he explained, the purpose and the function of the 16th Amendment was to assure the constitutionality of his proposed Corporation Income Tax Act, passed on 1909 in a session of Congress. And the amendment did not authorize any income tax on U.S. citizens. In his message to this joint session, he called for a bill to impose a tax of only 2% on income of corporations. He described his proposed corporation income tax as being in form and substance almost exactly the same character as that income tax law involved in the Pollock decision of the U.S. Supreme Court, wherein the law was ruled to be unconstitutional, and President Taft considered it unlikely that the court would reverse their ruling in that Pollock case. And therefore, in order to assure the constitutionality of this income tax on corporations, he proposed this constitutional amendment that would override the crux of the Pollock decision and thereby assure the constitutionality of his new proposed 1909 corporation income tax. Now, once this was supposedly ratified, thank you, well, we know it was not legitimately ratified. But if you even say it was legitimately ratified, here's some of the rulings that the Supreme Court themselves, after the supposed ratification, gave us. This is the cornerstone decision, by the way, that the IRS depends to establish its supposed constitutionality of the income tax, but only as an excise tax under the 16th Amendment. It involved, notice what it involved, this court case, monies accruing to non-resident aliens. That is, people kind of with a green card with a work permit here in the United States, but they are not citizens. The ruling said, yes, the 16th Amendment could tax them as well as tax corporations, but it could not tax citizens. That's Brashaber v. Union Pacific. And the court explained that the tax authorized by the amendment must be laid without apportionment. That is, it cannot be applied to citizens because Article 1, Section 9 still stands, prohibiting capitation taxes. That was one court case that ruled on it. And that became, the Constitution requires that all direct taxes must be apportioned among the states as a tax against, that's the only way they can tax citizens, not taxing you directly. The court stated the income tax is constitutional only as an indirect tax in the nature of the excise towards non-resident aliens as well as towards corporations. Another case This is Stanton v. Baltic Mining in 1916 as well. It held that the 16th Amendment created no new power of taxation. That is, the same powers of taxation the federal government had before the 16th Amendment were the same after the 16th Amendment. Nothing changed regarding you and I as citizens. We were not to be taxed by this. Other Supreme Court decisions have ruled that the income tax is an excise imposed on activities involving the exercise of a government-granted privilege. I ask you, when you go to work, is it a federal government-granted privilege for you to have that job? No. Now, perhaps if you're working for the federal government, and this is an argument that may have validity, if you're working for the federal government, okay, well, you might argue then it's a government-granted privilege for you to have a job, like the people at the IRS. Okay, we could tax them because they're working for the government. They've got a government-granted privilege, but the rest of us working in the private sector, no. And then it says such activities or corporations, activities involving non-resident aliens, green card, working or doing business in this nation, and that income is a measurement for determining the amount of tax for such corporations or non-resident aliens. Clearly, citizens are excluded from this taxing scheme altogether. 1918, Peck and Company v. Lowe. 16th Amendment, it said, does not extend the power of taxation to new or accepted subjects. That's specifically to you and I as citizens of the United States. Neither can the tax be sustained as a tax on a person measured by income. If you're a citizen, this tax cannot apply to you. Such a tax, it said, would be by nature a capitation rather than an excise tax and illegitimate. Capitation taxes, in other words, the courts recognized, even after the 16th Amendment was supposedly ratified, the court recognized that Article 1, Section 9, Clause 4 still stood. It had not been amended. It had not been removed. To repeal or amend Article 1, Section 9, Clause 4, you would have to change the language of the Constitution, specifically by this amendment to the Constitution. For example, this was done with the 18th Amendment, prohibition, being removed by the 21st Amendment. And the language of that amendment, look at the 21st Amendment, is extremely clear that it is completely nullifying the 18th Amendment and saying it is no longer valid. This was not done by the 16th Amendment. My friend Michael Peruca, who co-founded Institute on the Constitution, said federal income tax has served as a vehicle of tyranny by confiscating the people's money by central government and returning it to the states in a manner that coerces the states to be the agent of federal tyranny. Here is that wicked pattern again. They take it from your paycheck before you ever see that money, send it to the Treasury Department, and then to Congress, and Congress votes how to distribute that money, which is not 100%. They keep a large percent for themselves before they pass it on. This is wicked. This is a violation of the very structure of our Constitution. And you have to ask, how did they get away with this? Because everybody in 1916 who was watching understood this tax did not apply to them. And actually, many people were happy that, yeah, let's get the big fat cats in those corporations. And as I said, the reason they were going after the corporations was to force the corporations to open their books. The federal government didn't need the money, but they wanted to force the corporations to open their books so they could prove where the trusts were taking place and the violations of the Sherman Anti-Monopoly Act to enforce it and to put teeth in it. And so it has nothing to do with you and I as individual citizens. How they got it in is how the government always advances and expands its power. And the answer is war. That's right. This was between World War I and World War II that this began to ramp up. But by World War II, it was like, you need to buy war bonds. You need to be the good patriotic citizen. You need to support your government and you need to pay this income tax. The implication was that when the war was over, you wouldn't have to pay this tax anymore. And there was all kinds of propaganda. You can see little video clips from Walt Disney and others that pay your tax. They were doing a great job propagandizing the American people, and the people ponied up. And then what was their excuse then when the World War II came to an end? Okay, we got peace treaties or armistice. Now we got a Cold War. Yeah. We got this war now going on with Russia. And we got to build up. And so most Americans went along with allowing them to continue to violate the principles of our Constitution. And of course, by the time I grew up, and most of you in the room here began coming into this world, we were lied to from the very get-go. We thought, oh, of course it's constitutional. It has to be constitutional. It's right there in the 16th Amendment. That's what the 16th Amendment means. No, it does not. If you go back and actually look at the purpose for that 16th Amendment originally, as well as what it meant not to mention that it wasn't legitimately ratified. So if you put all that together, we shouldn't have that 16th Amendment at all. But I dare say it's going to be extremely difficult to get rid of it. Now let me go on quickly, because I know my time is running here, to talk about the 17th Amendment. Because while Bill Benson was going into the archives of all 48 states in the Union and examining what they did in their ratification, so-called, of the 16th Amendment, he also happened to look at what they were doing with the 17th Amendment. And he discovered that as the 17th Amendment crushed one element of our constitutional balance of power, because before the 17th Amendment, all the senators were chosen. They were selected by the legislature of the state. So if you guys are the legislature, you would be choosing who's going to the Senate. The Senate was not voted on by popular vote. And so that system allowed the state legislature to have a check on every bill that passed through the federal government, because they could instruct their senator, this is how you're going to vote. And if the senator said, I don't like that, I'm not going to vote that way, you're fired. We immediately remove you. We'll replace you with who we choose that will do the will of the legislature. So the Senate was designed to be the states represented in the federal government to stop anything that they did not want passed in Congress. Now, the 17th Amendment eliminated this important check on the federal power, and Bill Benson's research found that it was not ratified, just as the 16th Amendment was not ratified. Quickly look at the levels of government and the branches. The design in the legislative branch between the state government and the federal government is the state legislature had all power in the Senate. With their two senators, they could instruct them how to vote, remove them when they would not do their will. This was a powerful check on the federal government. So consider the spending of the federal government. The state legislature could always determine whether their senators were going to vote for or against the big beautiful bill, for example. We could take other examples. But every piece of legislation passing through Congress, the state legislatures had a voice in that and the power to stop anything they did not want to take place. So the two most destructive amendments, in my view, were never properly ratified. The 16th and the 17th Amendment, and they've had an enormous impact in destroying the power of the state governments to protect we the people from a rapacious and evil federal government, now with the IRS in view. So the question is, what do we do? First of all, we need to pray. We need to pray that America repents. And this is a huge task to bring Americans to repentance. And we need to pray that Americans would have their eyes open to the truth I have just shared with you about the fraudulent nature of the 16th and the 17th Amendment in their ratification process. Then next, we need to speak with our state legislators, those who represent us. We need to have a voice that objects to this. There need to be state resolutions that say to the federal government, this was not properly ratified, and here's the evidence, and you threw the guy in jail who brings the evidence, and you banned his book that gives us the evidence. And by the way, there have been people that tried to replicate Bill Benson's research, and they've gone into state archives and discovered what? Those documents have disappeared, somehow mysteriously disappeared, and now there's the blank spot. So it's like, whoa, talk about these criminals. Yes, they are criminals. And then we have criminals running the show, both at the state and the federal level. But we, the people, are the ones to whom they answer. And if we say, look, Article 1, Section 9 clearly says that this entire scheme of capitation taxes is illegal. And we demand our state legislatures, first of all, issue a resolution and say, this has to stop, this is illegal. You cannot violate the supreme law of the land. And then we need to have some brave legislators who would put forward bills to put the IRS out of business in a particular state. Thank you. I have a friend who was in Georgia. He's now in heaven, but he proposed the one bill that would have put the IRS out of the state of Georgia, and people, instead of writing their check to the Internal Revenue Service or the Treasury Department, would write a check to the Treasury of the state of Georgia. They'd fill out all the paperwork like you do, and then Georgia would indemnify them, the guarantee that they would not be legally attacked by the IRS if they sent their money to the state legislature. State legislature had a panel that was going to evaluate the constitutionality of every element of the federal budget, and the percentage of the federal budget that followed the Constitution, they would send them that percentage of money from their state. But the percentage that did not follow the Constitution, they would not send them that money at all. Of course, that would mean Georgia would be cut off, have no federal road funds, no federal school. All the federal grants going to the state would immediately end. But Georgia would say, fine, we'll depend on our own people. We don't want your nose in our business, Washington, D.C. Sadly, that bill did not go forward, and he died. But there were a couple other states I understood that took up that same idea, used his model legislation to say, we could put the IRS out of business. And I think he could have added some teeth to his bill that would say, you have 30 days if you work for the IRS to leave the state of Georgia. If you refuse to leave, we're putting you in prison. And if you come back into the state of Georgia as a representative of the IRS of that agency, we are going to arrest you. We'll fine you, maybe $5,000 first offense, $10,000 second offense, $100,000 third offense. We'll put you out of business and we will criminalize you, because of that indeed is when the relationship between the IRS and us individual citizens, they take our money, they are criminals. They are thieves.